All right, well, good evening. I'm Stan Bissey, Executive Director and CEO for the Los Angeles County Bar Association. Thank you all for being here, and I'd like to introduce our moderator for this evening, Carolyn Shining. Carolyn is a member of the LACBA Board of Trustees and the chair of the Future of Lawyering Committee. She is the past chair of the Small Firm and Sole Practitioner section and LACBA's delegation to the California Conference of Bar Associations, where she was recently awarded the Charles English Spirit Award for contributions to the CCBA. She's also a member of our Trusts and Estates section and our litigation section. From 2020 to 2022, she was a member of the State Bar of California's Paraprofessional Working Group. She's a partner in the firm Shining and Park Law and has been active in studying and sharing information about state bar programs since 2018. Carolyn, thank you for your leadership and service. The floor is yours.
Okay. Thank you, Stan. Good evening. And I understand we actually have a very distinguished guest, Brandon Stallings, who is the current chair of the Board of Trustees of the State Bar. And I gather, Brandon, you would like to do some introductions.
Absolutely. Thank you for having us. Would first like to introduce our executive director, Leah Wilson. Then we have Steve Moad and Chris Jaggard, all from the State Bar, who will be presenting on various aspects of the State Bar. And if you're okay, I can launch into a little bit of an introduction and hand it over to Leah.
Please do, and welcome.
Thank you.
Did you want to provide a little bit of the ground rules, Carolyn, or a little bit of an overview of how it's going to go? I think we were going to do that first.
Okay.
Yeah, thanks.
Okay, sure. No, we're here, and welcome everyone who's here. And I see people still coming into the Zoom room. We're here tonight with Leah Wilson and some other distinguished members of our California State Bar, and also Brandon Stallings, who we're going to have a town hall on issues that relate to the State Bar in 2024 and 2025. There have been a lot of new programs, a lot of discussion, a lot of debate over these things that are coming up with regard to changes to the way we practice law, changes with regard to the budget, that and actually importantly a proposed fee increase that relates to a lot of those different things. I know a lot of people that I speak to at LACBA and other bar associations have a lot of questions. We've pulled together a lot of bar associations who've sent in public comment, and we try and encourage people to provide their own public comment. But we've also provided a compilation and a consortium, if you will, with Kristen Aden, and before that Ann Park, and our past presidents, to talk about and often criticize a lot of these issues and proposals. So one of the goals of tonight was to try and bring together some of those ideas, some of those thoughts, but also let Ms. Wilson, Leah, if I may, really explain in detail where the State Bar is coming from in a way to our general membership and the public that really hasn't been done before, that I've seen in a long time, partly because of COVID and partly because of how busy everybody's been, but also there are just a lot of these different proposals. It's a lot of ground to cover. So with that, we will hopefully have some time for questions at the end. We'll definitely have a conversation here. I have some questions pulled together from my conversations with a lot of people and emails that I've been getting. So with that, I'll let Mr. Stallings, Brandon, again, if I may, go ahead, introduce our other distinguished guests.
Absolutely. So as I previously mentioned, we have Leah Wilson, who's been our executive director for many years, who really started with the organization in a time of turmoil and upheaval, and has really been a huge champion for reform at the State Bar. We have Steve Moad. He's a special counsel over regulation, and Chris Jaggard is a deputy chief trial counsel. And so I think with these three staff members' perspectives, hopefully we can give the LA County Bar Association, you and your members, a little bit more information, a little bit, and engage with some of the facts we're going to be talking about, some of the proposals. And really, I just wanted to start things off by, I'm not sure how familiar your membership is with the path that the State Bar has taken, really over the past decade, going from having both a regulatory and a trade association function. Now the State Bar is focused purely on the regulatory side of things. And so certainly it's less of a, I guess, a fun type posting. If you've ever worked with the California Lawyers Association and Jeremy Evans, he was last year's, preceding last 2 years, he was their president. And I always kind of joked with him, like, hey, you know, you guys got the fun parts of the bar, you know, the sections and kind of the trade association functions. And I got left with kind of the not fun parts. But, you know, through that not fun wrestling with the issues, wrestling on how to regulate lawyers, I think we've really, really come a long way since, you know, and I think the elephant in the room is the Girardi case. Girardi has certainly sought to define what the State Bar has done over the past couple of years, and really what it's done is it's given us a really good opportunity for us to examine ourselves as an organization, to be open and transparent about our failings and try and rebuild the trust of the people of the state of California in the practice of law. And so while I think that certainly the State Bar and trade associations might not see eye to eye on many things, I think that one thing that we can agree on is that when the public trusts in the practice of law and in the profession, that lawyers are being ethical and that lawyers will be held accountable for any of their misdeeds, that the public, when they have that greater trust, they have a little bit easier of a time retaining attorneys, trusting attorneys, and what attorneys are doing is actually fulfilling their fiduciary duties to their clients. And so I really see this this is kind of a shared ideal with our two organizations. And so to that end of rebuilding the public's trust, we've done a lot in the area of client trust accounting, and that's what Steve Moad has been really wrestling with and engaging in. We had a task force that was set up, and we're looking to refine that, but really try and avoid any Girardis in the future. And then on Chris Jaggard's side, really trying to shore up our Office of Chief Trial Counsel, and to do so in a way that meets with statutory obligations and standards that Leah is going to be talking about in a little bit. But really, kind of from my perspective, also as a lawyer, I'm a prosecutor in Kern County. And when I think about a regulatory agency and what do I want as a who do I want as a regulator over me? And what it comes down to for me is I want the investigator or the lawyer who's handling my case to be experienced and to know what the practice of law entails, to know the rules of professional conduct, and to see, be able to, I guess, see the forest through the trees, be able to use that experience to determine whether I have committed some sort of malfeasance. And I think that when you view the discipline system and the professionalized discipline system that we have in the context of the rest of the United States, I think that our professionalized discipline system really stands on its own as far as having dedicated investigators, prosecutors, and then a State Bar court who wrestle with these issues day in and day out. So as a licensee, I want someone who's really familiar with the laws and the ethical duties we're bound to, instead of, like in other jurisdictions, maybe someone who works for the Department of Consumer Affairs. Maybe you get a hearing judge who doesn't really practice law, has no concept of various ethical rules. And so when we ask for a fee increase, we're asking to shore up that professionalized discipline system to make sure that if you are ever investigated, that you're investigated by an employee who has that experience and that background. So those are my opening remarks. I know that we're going to have time for questions and answers later, but really want to hand this over to Leah to walk us through how the State Bar proposes shoring up the discipline system, keeping the lights on, and what that looks like for licensees.
Okay. So Brandon, if I may, I think I gave Brandon short shrift in his introduction. Brandon, in addition to being a public servant in Kern County for many, many, many years, and probably, I think your entire career, has been on the State Bar Board of Trustees also, probably for almost a decade, and given great service to the State Bar and all of Californians. And just want to thank you for that. And I apologize for you were in court, I think, so we weren't sure if we were going to get you today. And we're very, very lucky to have you here, and definitely have both you and Leah here is a real treat and an opportunity.
I appreciate that. And if I could just add, I neglected to mention that really had the opportunity to work alongside distinguished LACBA members in the Civility Commission. That was a commission that Justice Brian Curry out of the 2nd DCA chaired. I was a co-chair or a co-vice chair with him. And we really got to engage with members of LACBA. And so really want to thank you and your organization for the countless hours of work that went into the Civility Commission. And so your organization has been really, really powerful at the state level. So we appreciate engaging with you. So Leah.
All right, so thank you. I am going to share my screen. Let me get this in presentation mode. All right, can you see the screen? I'm going to assume yes. So before I get started sort of in the nuts and bolts or nitty gritty of our #1 priority as an organization this year, which is the fee increase, I wanted to give a little bit of overview, just a reminder to you about why the State Bar is important. And Chair Stallings really teed this up well by talking about, as an attorney, why you want a robust regulator, a well-supported and resourced regulator. And so what you see on the screen here are really the 3 pillars of the work that we do. In licensing and regulation and discipline, you see that we obviously develop, administer, and grade the California bar exam. That's about 12,000 applicants a year that we're doing that for. We accredit and register about 18 schools, non-ABA law schools in California. We proactively monitor client trust accounts, and I expect that we're going to be talking about that a little bit later today during the Q&A. 116,000 of you have reported having client trust accounts. We have a little over 10 billion on deposit as of this year in those accounts. We process and prosecute complaints about California attorneys. You know that in the last 12 months, about 17,000 complaints have come in, and we've met the statutory case processing timelines for those cases in about 86% of the time. So a tremendous amount of work in this space in terms of reimbursing victims of attorney theft, over 6 million reimbursed in the Client Security Fund over the course of the last 12 months. There was a question in the Q&A about the timeliness of that reimbursement. We've reduced time to payout by 43% between 2022 and 2023. We monitor hundreds of attorneys on probation every year. In terms of advancing the ethical and competent practice of law, of course, the big rule that has recently come down is Rule 8.3. Really, finally, California implementing such a rule, one of our many responses to Girardi. And we've had hundreds of complaints come in pursuant to that rule. And interestingly, these complaints are more likely than any others to proceed to the investigation phase. Also, important work done by our board this year, or just last year, issuing guidance to all of you on how to use and integrate AI in the practice of law. So very important work that we're doing on the rules side. I saw a question in the chat about why does the State Bar treat attorneys as if we are your enemy, or you are the enemy of the public. And I'm really sorry that that is sort of the sentiment that's out there. I do want to point out that we are doing quite a bit to train and support attorneys in compliance. A tremendous focus recently has been in the client trust account space, but we've put on programming and issued, handbooks and tutorials that have been viewed and participated in by over 23,000 of you in the last year. And then just lastly, but not least, in terms of our work on access and inclusion. We are the single largest funder of legal services in California, issuing or distributing over $150 million in grants to legal aid organizations in the last year. We also do the seminal work that's out there in terms of documenting a diversity of the legal profession and working to eliminate bias in the profession. And if we have time later today, I will share with you some LA County specific data from our most recently published diversity report card. So now, what is our focus today? Our focus is a fee increase. Carolyn, you mentioned a lot of other initiatives, and I want to make sure that we are able to talk about those. But this is really priority number one for the State Bar. We are seeking a fee increase of $125. And you can see that that breaks out into two components. $95 for what we call keeping the lights on or maintaining public protection, and another $30 to increase public protection. The components of that 95 you see on the screen are lease obligations. We sold our building in San Francisco after years, I think, of legislative kind of pressure and requests that we do so. We did generate about $30 million in net proceeds, and those proceeds are helping us make it through 2024, but we will need funding to support the lease obligation going forward. Similarly, we need funding for our contractual obligations, $35 of that $95 to maintain public protection. Comprises our contractual obligations to our staff, merit increases, COLAs, and then a small portion for IT licenses. Any of you that are small business owners, I hope you can relate to the really rapidly escalating costs that we are experiencing in terms of IT licenses. Lastly, in this first bucket is funding our existing staffing levels to address our fiscal challenges, as well as to reflect what was happening to us kind of in the throes of COVID. We adopted a budget that reflected a 15% vacancy rate. However, subsequent to that, our turnover rates plummeted, and we have realized a lot more stability in our workforce at the bar. This is really positive on many fronts, but it means that we are not actually funded for the staffing level that we have. So those three components total $95, and really that's what we need to keep our doors open. Then you see at the bottom another 30. This is an additional investment we are seeking to improve our impact. First and foremost, increase staffing for the Office of the Chief Trial Counsel to meet new case processing standards that the legislature asked us to develop. Secondly, a diversion program, funding to support diversion. And there are three prongs to this diversion program. Two of them I call pre-complaint. One is an expansion of the mandatory fee arbitration program. Another is a diversion of complaints about communication and failure to return client file away from OCTC to another part of the State Bar. And then the third is expanded diversion in OCTC. So we're asking funding to support this diversion effort. And importantly, if the diversion program is funded, the needs for OCTC staffing reduce. We're also asking for funding for the complaint review unit. This group hears appeals of OCTC's decision to close complaints, and it is currently facing a very significant backlog. And last but not least, funding to support the expansion of the Client Trust Account Protection Program to include compliance reviews and audits. You see here a TBD for IT. We're still working on that, but I believe our board is taking a position that whatever we need for IT, we should figure out how to fund without asking for an actual increase in the 125. So let me advance the slide. I'm sorry.
And just so that people do know, there are two experts in some of those areas with us, Chris Jaggard and Mr. Moad. So on CTAP and on the diversion program, we do have some other experts here to talk about that. And we'll get into that as questions will come up and after Leah, after you finish your presentation. So people just don't know, it's not just going to be 50 minutes, as much as we love you, Leah. We're gonna break it up a little bit.
No, I'm gonna let me keep going. So we've
Okay.
had one fee increase in the last 25 years. This, I'm going into a section that's really going to explain the why we are in the situation we are in and why we certainly believe a fee increase is warranted. So one fee increase in the last 25 years, had we kept up with the pace of inflation, it would be over $700, our licensing fee. We did get one fee increase in 2025. This slide just illustrates for you that almost as soon as we get a fee increase, the funds are outdated. And that's because the way that the State Bar is funded, it is funded for the needs in a point in time, and there is no mechanism for ongoing routine increases. So here you can see in 2020, we received $13 for staff COLAs, and the cost of those COLAs today is $34.75. Another, what I call a macroeconomic indicator, has to do with our overall licensee population. Sometimes I hear, well, Leah, it doesn't matter that you don't get fee increases because the number of attorneys paying every year grows. And that's true, but the rate of growth is small. And what you can see from this slide is that our active attorney population has grown by 9.5% over the last 10 years, while our inactive population has grown by 43%. When you look at the population over 70, you see an even starker picture with that group grow more than doubling in the last 10 years. And you all are aware, I believe, that if you are over 70 and inactive, you pay no licensing fee. Another macroeconomic trend has to do with the admissions, so new admissions to the bar. This is also a trend that's not going in the right direction from a budget perspective, certainly. Over the 10-year period from 2003 to 2013, we had an annual rate of growth of 2%. So this is new admits after taking the bar exam. In the last 10 years, we've seen an annual decrease of 4.5%. So what you see is compression, less people coming into the profession, and within your population of attorneys, you see more and more folks moving into an inactive status, and more of those inactive lawyers being over age 70. So what is the result? The result is we have insufficient revenue to meet our needs. The licensing fee that you pay, the general fund unrestricted licensing fee, generates about $88.4 million annually. The cost of general fund programs is $112.5 million, and the cost of OCTC, State Bar Court, and probation alone is $99.3 million. So you start to see that we are operating at a very significant structural deficit. Some of you might ask, well, what about the reserves? Can't you just tap into your reserves? So this slide shows you the status of our reserve. The general fund reserve got a real injection last year when we sold our building. We have realized net proceeds, as I said, of about $30 million. But we are using $22 million of that to shore us up for 2024. So we anticipate leaving 2024 with $14 million, or entering 2025 with $14 million in the bank, so to speak. And that is not enough money to take us through our projected 2025 deficit of $20 million. So I just want to provide a bit more in terms of context, how the State Bar stacks up to other licensing agencies, both other attorney licensing agencies, and you'll see some slides here about the medical board and doctors. So first up, our fee is lower than that of 17 other states. And you can see that even if the 125 was granted, we would not be the highest licensing fee in the country. And that is in contrast to the cost of living in California and the cost of labor. On both of those metrics, California is the highest.
Okay, and I just want to jump in there, Leah. And there are a lot of questions about kind of those real budget specific questions that you had. But a lot of the lawyers, again, that I've spoken to over the last couple of weeks have said, why, when New York and Florida and some of those other larger states have lower dues than what we're proposing, what is it about California? What is about where you're going that doesn't compare to New York or Florida? I've had more than one person ask me that very specific question.
Well, New York has a very different structure for its state bar, and I really can't answer that. I think New York it's hard to compare because they do not have a single statewide state bar in the way that we do, and in the way that I believe Florida does. I can't answer, the why. I'm not sure exactly what Florida is doing or is not doing. I do know that many people leave California to move to both Texas and Florida. I believe the cost of living is lower. I believe the cost of labor is lower, and those things are a reality and they do have an impact. But I can't answer that, on the fly here, but certainly happy to do some more digging about states that folks feel are more comparable. In terms of the medical board attorneys, the medical board just levied a very significant increase on doctors, 33% increase in 2024, and the doctor's licensing fee will increase by another 9% in 2027. Attorney licensing fees are now 30% less than those paid by doctors. And even if we got the $125 fee increase, we would still be paying less than doctors for the licensing fee. In terms of complaints per capita, the state bar receives more complaints per attorney than other states, including states with the largest number of attorneys. So you see that here. In terms of the medical board, we receive more complaints per capita when comparing doctors and lawyers, and we also investigate more attorneys per capita than doctors are investigated per capita. So this I would call an efficiency metric. We are outperforming other states and outperforming our doctor counterparts. In terms of cost per complaint, our cost per complaint is lower than other comparable states. If you look at large states on average, or you look at all other states, our cost per complaint is lower. And that, of course, is because we receive more complaints per capita. And you can see the same thing here when comparing us to doctors. So what is my grand takeaway? My takeaway is we've had one fee increase in 25 years, and yet we have been able to perform at a level that is at least comparable to our counterparts in other states. On some measures, we are more efficient in terms of using our resources, and certainly we stack up well when compared to doctors. In addition to this comparative analysis, I also wanted to assure LACBA members that we are using the resources we have to make critically needed investments, even absent fee increases to do so. So in 2020, the legislature funded 19 new positions in OCTC. This was designed to help OCTC meet statutory case processing standards. Since that time, we have funded 27 more positions through internal reallocation of resources. Had we not done so, the fee increase today for OCTC positions would be almost double what it is. In terms of our conflicts program, this is the Rule 2201 program, the subject of a lot of scrutiny also related to Girardi. I just want to remind everyone that until 2016, this was an entirely volunteer-run program, meaning that the attorneys who handled those matters were doing so on a volunteer basis. The program transitioned to paid status in 2016. And since that time, the costs have increased by over 2,000%. You might say, oh, that's a problem. However, the state auditor came in last year, reviewed this program in depth, and specifically looked at the cost of the 2201 function, did not identify any cost savings to be had, but instead directed more investment in the program. This is something we have done without any related fee increase to do so. Lastly, we have cut cost. I mentioned that we had adopted a budget with a 15% vacancy rate as a way to try to shore up our budget. And I also mentioned that subsequently our turnover rates plummeted, and we now find ourselves at about a 7 or 8% vacancy rate. But for about a year, we did impose a very draconian vacancy rate and hiring freeze on the state bar. Some of you may have experienced that in a certain level of frustration with phone calls and emails not being responded to. There is, in fact, a very real impact of not staffing our operations. And here, the last bullet, you can see eliminated most travel and meeting costs. We have institutionalized the savings that were brought on by COVID, and that's about $1 million in our budget that we are saving as compared to the pre-COVID era. So I just want to transition briefly to other aspects of our proposal. It's $125, but then the proposal also includes a new structure for assessing licensing fees. Right now, we assess fees on a pro rata basis or a flat fee basis. If we did that, that $125 reflects about a 31% increase, which would be difficult for some licensees to absorb. So because of that, the State Bar began to look at new models for structuring the licensing fee, or new models for assessing the fee. And where the board landed is on a practice sector-based assessment model. And you can see here in the infographic on the far right-hand side, you can see the percent change in the licensing fee that would be realized by attorneys in each of the respective sectors identified. So those in the other, which we understand from our data is primarily retirees, solo and nonprofit sectors, would realize just a 4% increase over their current fee of $404. Whereas those attorneys in large firms and large corporations, defined as having more than 100 attorneys, would see an increase of nearly 100%. So this is a very important aspect of the model, and I do hope we get some questions about it.
I will go back when we have that, because quite a few members of LACBA, and I was a small firm. I am a small firm, but when we talk about that particular decision-making process, I know there was a survey where you were asking people what did they think. Some people were a little question why there wasn't a box that said none of the above. You asked which of these models would you like. What were the results of that survey? Was that taken in, what are your thoughts on what feedback they gave you?
Well, I have several slides on that. So if you want me to divert to that now, I can. But what I was going to do, I think I just have 2 more slides, sort of the overall, and then open it up to Q&A, and I could certainly, go into the fee increase.
Go right ahead. We'll put a pin in that.
Okay, so the kind of final component, so really, if you think about this fee increase request, you can think about it as a 3-legged stool. One is the dollar amount, $125 if assessed on a flat fee basis. The second is the new fee assessment structure. We are recommending a transition to a practice sector-based structure. The third leg of the stool is to adopt an annual CPI adjustment. And the proposal specifically is that annual increases pegged to the California Consumer Price Index would be automatic. If the State Bar sought anything in excess of that CPI, we would have to justify it vis-a-vis a process similar to what we're undertaking now. We see that this approach would have benefits for both the stability of the State Bar and predictability and moderated increases for attorneys. So lastly, and then I'm going to take the deck down and see where we go with Q&A. What happens if the fee increase is not approved? And here I'm really going to focus on that $95, maintaining public protection, keeping the lights on. And here you can see that totals about $20 million. You can see that what we have in our general fund reserve is 13.9 or $14 million. So we don't have 20 million in our general fund reserve. We could get legislative authority to tap into the Client Security Fund reserve, for example, to augment our 13.9 million, and that could conceivably take us through the year 2025. But then what? With no fee increase and no more reserve funding, we would be forced to start looking at cutting costs. When we talk about cutting costs, 88% of our general fund comprises personnel costs. So it's really hard to talk about cutting costs without talking about cutting people. Every 6 employees is about $1 million, all in salaries and benefits. So you're talking about, 120 positions to equate to a savings of $20 million. So this is very serious for us. It is kind of an existential crisis we're in terms of the funding we need to maintain public protection. With respect to improving public protection and the remaining $30 of the fee increase request, we are not going to be able to achieve any of the objectives that either the legislature has asked of us or the public expects of us or you demand of us without some additional investment. So with that, I will stop sharing. I see there's lots in the Q&A, and I'll defer to you, Carolyn, on how you want to proceed.
Okay. Well, I think honestly, there's a question in the Q&A, and it may be mundane, but I think this actually affects pretty much almost every single practicing attorney in California, and that is the ethics hotline. And when one calls the ethics hotline these days, and when I first started practicing here many, many years ago, you could get a call back in a couple of hours. And what my understanding is that has changed. And understanding all the different, very deep, very serious policy issues and budget questions that you have, how can you help us with the hotline? It's a very important part of our practices, and I understand from a lot of people it's been real problematic lately.
Yeah, the ethics hotline was really hit by that hiring freeze and the vacancy rate cap that I mentioned that we are seeking funding to reverse. So the ethics hotline, there was like a perfect storm of staff who went out on various types of leave and those freezes. So they were not allowed to backfill. Normally, if somebody goes out on leave, you could, for example, bring in a temp. The ethics hotline was not allowed to do so. We operated for months with one staff person in the ethics hotline. So that's what happened with the hotline. We have kind of brought in some additional staffing. And Steve, I don't know if you're able to speak to this at all. Folks are getting trained, but I don't think we are in the near future going to be staffed back up to the level where we can do it, exactly like we did in the old days. I don't know, Steve, if you have anything to say in addition to that.
That's correct. It is not yet fully staffed. We are always looking for ways to improve our operations that may include a way of allowing people to chat with the hotline representatives, that way they can staff more calls, if you will, or more chats at the same time contemporaneously that would allow them to service more people. But that's still an item for discussion. But we're always looking to improve our operations.
Can we talk a little bit about, and it go back to the way the 2018 reforms really impacted how the state bar operates? Again, another very simple, very fundamental issue. But again, I find in talking to people that still people many years later don't understand and really get what is discipline and what is not discipline. There sometimes seem to be other programs that look like discipline or look like additional programming or look like going beyond a disciplinary function. How really are we handling that split in terms of programs beyond discipline that are in your budget?
It seems like I'm having a little bit of internet problem. Can you guys hear me?
Maybe it's I don't want to throw that to Brandon necessarily, but maybe Brandon.
Yeah, I can definitely answer an aspect of that. So I think what you're touching on, if I am hearing you correctly, is diversion programs and whether or not that is something that we're looking into. Is that
No, just in general, when the CLA was carved away, when all those, you were talking about the educational side, the annual meeting side, those kinds of things. It feels like to some people that there is not a full and pure split between that sort of diversionary, very serious prosecutorial function versus everything else. So is there in your mind an understanding of where that line is drawn in California, how that impacts the budget? And even as a follow-up, how that it's different in different states.
So I think I understand your question now. So the when there was the bifurcation happened, there was a legislative mandate that public protection is of the highest priority for the state bar, and that if there's any competing interests, then we choose the option that protects the public to a greater extent. So for us as a board, every decision that we make comes back to that question: does this aspect of the organization that we're looking at, does it further public protection? Within that, there's if you've looked at our strategic plan, we break out really how the different elements such as the client trust account program, how that furthers that public protection, funding, Office of Chief Trial Counsel, how that furthers that. And then if you look into areas of diversity in the legal profession, there's this desire for us to instill in the the populace this trust that if I have a lawyer or if I have a judge who looks like me, then I trust the system to a greater extent. And so that's one of the things that we've focused on, albeit in a much more limited way, given the bifurcation. A majority of that work is done by Council on Access and Fairness, several other organizations that we still partner with to do some of the studies that inform our work. But really what it comes down to on the day-to-day decision is the licensing fees. And there was a whole change in the terminology that we use. We're no longer over California State Bar members as we regulate licensees. That was something that for the legislature was very important, that we get away from this trade association type look and type feel and the way we treat licensees, because they really wanted to know that as a licensing agency, we were approaching it from, hey, how can we ensure that the public's protected, not how can we ensure that attorneys are protected. So I don't know if that answers your question, but that's really what it comes down to, us and the Board of Trustees.
When I go into, sort of the budget proposals and look at sort of what the state bar is facing, and we can get into sort of questions I think people have about the building and about, demographics in terms of new students, but it is confusing to the extent that so much of what the bar does relate to the IOLTA functions and funding of the different legal services. How do we carve that out when we're looking at trying to analyze what's being sought, trying to understand why this fee increase is being requested? And Leah, maybe that's a good question for you. Where do we get that information? Carve out half of really what the budget relates to the IOLTA money coming in and being paid out to all the legal services?
Yeah, it's more than half. I think we have like over 200 million in revenue budgeted for legal services this year versus 88 million attorney licensing fees. I'm not sure about carving it out though. We do charge all of the grant funds and admin fee, and that does support our sort of operations, IT, HR, finance, etc. So they are effectively paying their fair share. They pay a portion of the lease costs, for example, based on their employee headcount and square footage. So to the extent that we are able to appropriately charge off to those grant funds, we're doing that in order to reduce the funding shortfalls in the general fund.
So now I'd like to kind of switch a little bit and see if we can get into some of those IOLTA issues. And the one question that I have is, two questions. One is a very specific question and a general question. One is, in part of the increased funding, does that include the random audit? When you say auditing, is there still a plan inside the state bar starting next year in 2025 to randomly audit attorney IOLTA accounts? And then the second question is just, it's more, people do feel like someone who had a question in the Q&A, as if they are under attack, that as if everyone and, all the small firms, all the people who are really trying to get out there and help the community are being painted with the brush of one very, very not horrible attorney who was, no one will disagree that was just a tremendous loss to so many people. But so many attorneys are doing a good job and are really working hard to make sure their IOLTAs are perfect. And they feel as if they are being painted with a terrible brush of, we're going to look at everything everyone does. And they feel very unfairly about that. So will we be seeing random audits, and how do you kind of approach that? Maybe it's gone too far in terms of looking at who are the bad apples.
Let me just jump in before we get to the random audits and just address a couple of your comments. So I think that, you touch really on what I talked about at the very beginning, that this is something that we as a profession, we're going to have to come back from. It was a very public thing. Anytime the Real Housewives of Beverly Hills is involved, the general public's going to care more about it. And it was a perfect storm of individuals who may not necessarily be made aware of legal issues or disciplinary type proceedings involving lawyers. They now hear about it and they're now concerned about it. So really, I think it's incumbent on each individual lawyer to rehabilitate the profession, just the people that they come in contact with, to hold themselves out as a professional. Certainly, we've tried to address some of the incivility concerns that we keep on hearing about through making recommendations to the Supreme Court about civility type issues, way to address it. So I think each one of us can really bridge that gap between what people think they understand about the legal profession and what it actually is. And so the public perception right now, I think, is negative. And I don't think it's so much more that the state bar is coming down hard on every single individual, but every single complaint that comes in can be reviewed up to the Supreme Court. And that's whether or not the state bar closes out a case or proceeds all the way through discipline with some sort of sentence or discipline imposed at the end. And so we have to approach this from a very circumspect standpoint, and make sure that the investigations that we complete are done so in a fair and impartial manner that is not clouded by some sort of impartiality or partiality rather, where it's tied to an existing relationship. So that's why the 2201 program is really important. That's if someone on the board of trustees or state bar staff, if they have a complaint filed against them, or there's some other conflict.
You're gonna have to slow back up on that one.
Sure. So Rule 2201 program, this is whenever someone files a complaint against, let's say myself, alleging some sort of professional misconduct, instead of being investigated by the Office of Chief Trial Counsel or Chris's group, the Rule 2201 administrator would actually review that case against me, assign it to an investigator, and then go on to being assigned to an attorney. That Rule 2201 is independent. They're basically an independent prosecutorial body. We oversee budgeting, and that's one of our main goals really in the past decade is to shore up that program. And so we don't have a situation like Girardi and the conflicts that existed in all those complaints that were not followed through with. So that's something that we as a board are trying to do to rehabilitate rehabilitate our image in the public, and to hopefully ensure that the public trusts our discipline system a little bit better. So
those are new new guardrails for the board and for state bar employees. But I guess what I'm kind of trying to get to is what the regular attorney feels as if the state bar is really not out for them. That because again, you explained to someone you're not a member of the bar, that came with a lot of prestige that we once had with regard to our profession. What can the State Bar of California do to help the practicing lawyer, who is a good sized stakeholder in what the State Bar does, help the practicing lawyer feel more invested, especially when you're asking for fees and you're asking for changes in the legal practice? How do you make what we do every day as private practicing attorneys, is shored up on our end?
Can I just ask Steve to jump in, because he can also, in answering that, respond to the question about compliance reviews and audits. Before he does, I did want to just say, I get it. I mean, I'm looking in the Q&A and there's lots of stuff here about, why do you treat us as if we're the enemy? I do want to say that this proposed fee structure is a recognition of the value that solo, small firm, and nonprofit attorneys play, particularly with respect to that justice gap and serving individual clients. And really, in recognition of that, we wanted to do some cost shifting for equity considerations, and because we understand the value. So I did want to just sort of provide that as a bit of context and then turn it over to Steve. Steve, there's also a specific question in here about what are we going to do to help people be compliant on client trust accounting stuff.
Yeah, great. Thanks. I will, the compliance reviews will be subject to funding to some degree, because that's, as Leah talked about, some of that funding is dedicated to that. But we do think that's a very important aspect of the Client Trust Account Protection Program, and frankly, of our support for solo and small firm practitioners in particular. I've noticed the comments as well about the lawyers being the enemy, and I would reiterate Leah's statement that that's not really the case. I can understand why sometimes people may feel like that, but really misconduct is the enemy, right? We're here to protect the public. And so what we've done is really make this proactive Client Trust Account Protection Program to prevent misconduct. And we have used what we have learned from the Client Trust Account Protection Program to develop support for those who are potentially at risk of committing misconduct. And that support is to educate them and help prevent that misconduct. So one of the things that we've learned is that lawyers know generally what the rules are, and they know that, for example, a reconciliation has to be performed monthly of all of their trust accounts, but they don't really understand how to perform that reconciliation. So we have posted on the website several individual one-off trainings, and we are creating an e-learning session on how to maintain your records and conduct that monthly reconciliation. And that's really what the compliance review will be about. That e-learning course we expect will be posted in June, maybe early July, and will be available for MCLE credit, and will also be available on our website without MCLE credit, so you can have your bookkeeper or your office manager or whoever it is also take the course, so they're familiar with how to do those things. And then the compliance reviews themselves, I would argue, are another support mechanism for those solo and small firms. I saw that there was a question in the chat about, does that mean that the Office of Chief Trial Counsel is going to get the compliance reviews? And the answer is no, not unless there's a referral from the regulation division to the Office of Chief Trial Counsel. And that's important because there are many outcomes of a compliance review that would not involve discipline, right? Well, obviously, we would refer to the Office of Chief Trial Counsel intentional misconduct and things along those lines. But I am eager for people to have an understanding of the compliance review program, because I think that once they do, some of those concerns will be allayed, in the sense of they will see that there are a number of outcomes that are, hey, we noticed that this is your practice. These are some best practices that you may choose to involve in your practice that may help you. Obviously, some attorneys could look at that and say, hey, we got through this state bar audit program, and have implemented any findings and whatever, and use that as a marketing point, frankly. I know some CPA firms are looking at that for the same reason. So I really think there's a great opportunity here, and that's one of the things that we're looking for this year is we plan to conduct 25 voluntary compliance reviews this year. Number one, to test our procedures, and number two, to give people some understanding of what going through a compliance review looks like. So hopefully that gives you some idea of the supports that we've been putting in place.
No, those are that's really good information. And something you didn't touch on again that I've heard a lot of people ask about is when the CTAP got rolled out, and even this year, associates and people who are not managers of, in larger firms or middle-sized firms even, had to check some boxes and talk to their managing partners. What kinds of things can you tell us about what are the obligations of an associate, of a contract attorney, a partner even who doesn't, there's a junior equity partner. What are their responsibilities and how is that going to look for them? A lot of concerns there.
Yeah, great question, Carolyn. So it's interesting because a lot of people, both last year and this year, would write in, hey, I don't ever write checks, so this doesn't apply to me, right? And really that's looking at it the wrong way, because the duties imposed by Rule 1.15 go well beyond the bookkeeping aspects of maintaining a trust account. There are many duties in there that do apply to the actual lawyer who's handling the case, even if they don't ever receive checks from the client or on behalf of the client, and there's some other partner managing the trust account from that aspect behind the scenes, right? There are other duties in 1.15, and so it's really important, and really CTAP has been a great educational tool to get that message out. And as you note, we're still trying to get it out because not everyone's gotten it yet.
Okay, I'll put you in the hot seat on that one more step further. Because I'm licensed in Illinois, and in Illinois, there's a very strong provision that if you see your supervising attorney doing something unethical, in addition to the other rules, you must report your supervisor. And there are many an associate who dreads that day. What about here with regard to the CTAP? If what you're suggesting is that, yes, if you're just working on a case and you're making sure liens get paid or there's a division of funds, again, what is that associate really? You're asking a lot of someone who is not in charge of funds at a firm who gets a paycheck, aren't you?
Well, what we're asking of them is what their obligations are, right? So their obligations are to identify and discharge liens and things like that. It would, if depending on the firm, it may be the obligation of the managing partner to make the payments or of the bookkeeping partner to make the payments and divide the funds correctly. And our rule is not the same as Illinois', right? So we have our own version of 8.3 now, but Illinois' is quite different. And really what we're asking is that the lawyers go and ask that partner managing the money for the firm whether these things are being done, monthly reconciliations, etc. And what the guidance that we've given people is that based on our rules, that lower, junior partner is entitled to say yes if the managing partner tells them that those things are being done and there's no reasonable evidence to the contrary, right? That's what our rules provide, and that's what we've tried to educate people about as well.
No, thank you. And again, we've done LACBA's done seminars. A lot of organizations have done seminars, and I'm sure there will continue to be seminars, and everyone needs to go find those resources that are on the State Bar website. But maybe we could shift up a little bit. And thank you. Leah, one of the things that you mentioned in the budget was an amount and sums for a diversionary program. And I am not an ethics expert. I try and focus my attention on the things that are going to change our practice in the future, and we will have time to get to some of those. But this diversionary concept really did sound interesting. What is the budgetary impact? But before we talk about that, maybe if Chris, I think that sounds like that was your expertise. Could you talk about what that means? Is it restorative justice? Will these kinds of things be public? How new is this, and how different is this going to be for California attorneys? And we have a new PowerPoint.
Sure.
Leah, do you have some slides on that?
Yeah, Leah might have
We
some
just
slides.
have a slide, and I think Chris can speak, and maybe I will go in and backfill some of what he's going to
Yeah,
say.
Leah, did you want? I can handle the Office of Chief Trial Counsel portion of it, and then maybe Leah can follow up with the other portions there with the public trust liaison and the other
Okay.
office. But if Leah, do you want me to start with our
Yeah,
section
go ahead.
first?
Yeah.
Okay.
Go ahead.
And before I start, let me help frame it just a little bit more. Again, I want to ask about this in the context of people being concerned that the regular lawyer is under attack, and that every time a complaint comes in, you're going to have to hire an expensive lawyer to defend you. Even for the smallest of things, there's going to be a problem. So hopefully this is something that maybe you can assuage concerns of people who do get into trouble, that there will be ways in which the State Bar is going to look at that a little differently now.
Sure. I can start by the program is new. Our office just implemented it in approximately November of 2023. So it's only a few months old right now. So it is new and it is non-public. In other words, these diversion resolutions are non-public. It's not public discipline. It's not discipline at all, actually. So what it is it's kind of a quasi first-time offenders type of program for low-level or minor types of misconduct allegations. Some of them can be resolved through our intake without even going to the investigation stage. And these are, I'll get to the nuts and bolts in a minute, but just a broad overview in terms of what it is first. It's basically attorneys where their discipline and complaint history show that they don't pose a significant risk of harm to the clients or the public. And the alleged misconduct usually stems from issues that can be solved through education and rehabilitation. We do offer some of the conditions, for example, might be attending our ethics school. So our Office of Chief Trial Counsel has an ethics school that we put on, as well as these are MCLE programs, as well as the client trust account program. But the client trust account program is more about education on the rules than it is. It's not quite the same as what Steve's office is doing with the client trust account education. It's a little bit different. So those are some of the types of conditions that can be used in diversion. But it is basically people it's a first time type offense, low level. It's not strictly first time. It can apply to people who have had an issue in the past, but generally speaking, that issue would have been in the distant past. Maybe they had something 20 years ago or 25 years ago. So it's not strictly first-time offenders only, although that probably will be the bulk of what we see through this program. So it's an offer that is made to the attorney. There's, for example, a complaint comes in, we analyze the complaint. The offer would go out to the attorney. Do you want to enter this diversion agreement with our office? It does require a 270-day monitoring period. In other words, if the attorney had it, and it's not triggered by a complaint coming in. In other words, you don't get dropped from the program if a complaint comes in. You would get dropped, for example, if you have other discipline imposed, or if a complaint gets moved to the charging stage where we're going to actually file it in state bar court. So if you had another instance in that 270-day period, that would disqualify you from the program, and then we might also move forward the earlier complaint. But those are the types of things which would disqualify you. So it is a new program, but we are using it currently. We hope, obviously, we're using it with existing staff. And part of the fee bill request is obviously to staff it. Our portion of it would be, I think, approximately one attorney, one investigator, and 2 paralegals, I think is the request that is going in through the fee bill to staff this. So, and a lot of it, the paralegals would obviously be handling the monitoring side, monitoring compliance with the terms of the diversion. And I can give you some examples of types of, let me pull up a couple here, types of misconduct that might qualify for a diversion. Would be like a minor performance type, failure to perform type violation, communication, failure to communicate, conflicts sometimes potentially could qualify, minor failures to obey court orders, a failure to return a file, for example, certain failures to report certain things under Business and Professions Code 60680. Has reporting requirements, so failures to report might qualify. Failures to supervise is another one that might. We've had a couple we call them C cases. They're criminal conviction cases, so get quite a few DUIs. So potentially, we could offer diversion to a certain type of DUI that's potentially less serious than others. A first time, for example. Or potentially even a second, depending on the facts and circumstances surrounding that. So those are the types of complaints that might qualify for diversion, depending on the circumstance. And generally, as I said, it's like a first-time offense type thing where it's minor and there isn't a lot of client or public harm involved. Does that give you an overview?
Thank you. Yes. And now, again, I'm not a state bar ethics practitioner, but my understanding is that there will be changes with regard to what's made public and what's not made public on top of what you're talking about. So how does that interrelate?
I think Chris,
Yeah.
Carolyn is talking about the statute that is going to eliminate the concept of private discipline effective January.
I see. Right. I mean, this in some sense takes the place of that, right? So, but it's not discipline. That would be the main difference, right? So you're correct that as of January 1st next year, they're going to eliminate private reprovals, and we're not using them very much now anyway, although occasionally I think they're still in use. But the diversion program would I think take some of that, some of those cases, and those would be eligible for diversion. Some of the private reproval cases of the past, for example. Otherwise, the office is pursuing public discipline on cases where we feel like it's warranted. We would be pursuing the public reproval instead of the private reproval. But as I said, the diversion program will take some of those cases will qualify for diversion. So it's going to be a mixture, right?
And if I could just jump in, Carolyn, I think this slide here is the detail of what we actually requested to support the diversion program. And the reason that this proposal was submitted in conjunction with a report on this transition away from private reprovals was because of the expected relationship between eliminating private reprovals and the need to establish more expansive diversionary options so that you wouldn't just see more attorneys getting public discipline. There really is, I think, a strong legislative intent, and we've taken that to heart to ensure that discipline is, and the sort of the traditional discipline pathway is preserved for those more serious matters. So as I mentioned before, and Chris really talked about this one aspect of the diversion, which is post-complaint being filed in OCTC, but there are two other prongs that we have proposed. One is expansion of mandatory fee arbitration to include mediation, and also to be a program that is kind of advertised, because our utilization in California is much lower than other states we're seeing. Another aspect is this public trust liaison bridge program. I'm really pleased to report that just during a soft launch period of the first week, we've had 40 complaints not filed with OCTC, but instead filed under the bridge program, which is not disciplinary. That's where a client is seeking solely return of file or to get their attorney to call them back. So these are two aspects of diversion that, again, are pre-OCTC. that we have soft launched and implemented partially, but are asking for funding to expand. And we anticipate that if this is funded, we could see a reduction of about 20% of OCTC's current annual complaints. And that translates to about 16 positions. So in terms of the cost, we're asking for $550 per licensee. This is of that overall 125 to support diversion. If the diversion program isn't funded, our request will ultimately be more than 125 because we would need more positions in OCTC.
Okay, but let me drill down into that, and that's good. And it's really good on the, thank you, on the program description side, but on the budget side. On the budget side, if you are reducing down the number of cases on the more serious OTCC prosecution side, isn't that a savings that of time and money? Each prosecutor can take those cases and set them aside. So wouldn't that be a way to have this pay for itself or shift funds?
It does. And I don't be surprised to hear me say, I've got a slide on that. I feel like that's I don't know, some kind of commercial, but I do have a slide on that. So I'll show you here that the diversion program pays for itself. I think you couldn't have teed this up better, Carolyn. So this is the cost of the diversion program, 1.2 million in 2025. That's that $550 per licensee that we were asking for. Case processing, that's the new positions in OCTC at 3.2 million. So you can see a total of 4.4 million with the diversion program. Without diversion, 4 million. So in the first year, 2025, funding diversion costs $400,000 more than if you didn't fund diversion. But in the second and the third years, because the OCTC request is cumulative in nature, we're not asking for all of the positions needed to achieve the case processing standards in 1 year, but rather in 3. So each year, that portion of the request goes up. And you can see that by year 2, if you fund case processing diversion, you're saving $500,000. And by year 3, if you fund diversion, you're saving 1.3 million. So we see this as a package of proposals that if you make an investment in diversion, you need less positions in OCTC. And presumably another way that this could be looked at is the legislature chooses not to fund any new positions in OCTC, but they still fund diversion. And then I think you're right. The impact would be those attorneys that are in OCTC could redirect their time to the cases that are remaining with them. And we wouldn't necessarily be achieving the case processing standards that the legislature has asked us to establish, but we would be able to target OCTC resources towards those cases that remain. So whether you fund new positions in OCTC or not, diversion makes sense and it does pay for itself.
Mm-hmm. Good. No, thank you. And I would love to have you come back and talk more about kind of these things for people who make small mistakes, who have, a client who these kinds of things that you're talking about in diversion, and the lawyer assistance program too, I think would be great for another program in the future, so we get that kind of word out as to what those things are. But going back and talking, just kind of look at my notes. Oh, to the things that are near and dear to my heart, Leah, as you know, where are we going with the future of lawyering? And I don't know that this really ties into the budget at all, but it's something that I know you've, I've worked on, and LACBA and a lot of people have been critical of some of the proposals that have been going through some of your committees, the changes to the bar exam, the paraprofessionals, and I do understand, and you and I could probably sit down and we've talked for hours in the paraprofessional working group meetings, but where is the portfolio bar exam? Do you have any comments to add, and just kind of what it would be your next steps? What's the next things that you see with regard to the bar exam, where that's going? I know a lot of people who are on this Zoom have been a part of really responding to the BRC and the portfolio bar exam. Very unhappy with those proposals. So where do we go next?
Well, you know, we are waiting for the Supreme Court to make a decision, as I'm sure all of you are. So the Supreme Court is considering the Blue Ribbon Commission's proposal to transition away from the NCBE's NBE and to develop a California specific exam. So that's proposal number one that's pending with the Supreme Court. The second proposal is for a portfolio bar exam. This would be in addition to presumably a California exam, not a substitute for it. So both of those proposals are pending with the court. They have been for some months, and I think we're all waiting to see what the court directs. So I really can't predict that. But you know, you'll hear it when we do. In terms of sort of regulatory reform, it continues to be a hot button issue. This board has not taken up the issue in a way that I could say what's sort of the future position of the state bar. As you know, we are under kind of a moratorium on those issues until January 1 of 2025. And at this time, I don't anticipate a kind of revisiting the paraprofessional sort of conversation or sort of non-lawyer ownership conversations that were such hot button issues. Certainly not absent any kind of community groundswell to do so.
What does the news out of Washington and Oregon, has that, again, everybody asks me, what does the state bar think of that? And I say, I don't know. Come to our event. We're gonna, Leah, what do you think about Washington and Oregon, if anything at all?
Are you talking about the fact that they're adopting sort of portfolio-based pathways to licensure? I mean, a number of states are, and I think this is part of the what I find very interesting about California is, you know, a lot of states are exploring reform in ways that seem to be, you know, very challenging for us or we're disinterested in. And I'm not sure I fully understand why, but I understand that that is the sentiment. And certainly, as I said, I haven't had any conversations with the board, and our chair can speak up on this. We're not planning to relaunch any type of effort that I'm aware of right now, other than, as you know, the portfolio-based exam proposal is pending before the Supreme Court. So if they authorize it, we will, of course, move forward there.
And just a reminder for people, again, there's so many issues. The portfolio bar exam is a pilot, right? It is not we're going to change everything instantly. It is still just a pilot, right?
Yeah, it would be as articulated in the proposal pending before the court.
Mm-hmm. Okay. One odd thing that I don't know that we talked about in advance, but as every day, you know, I go through my day and I use different computerized machine learning tools to help me in my practice. I see and I think about, we had that robo-lawyer fellow who OCTC and Mr. Cardoza came out wisely and immediately said, don't you dare cross California's borders. Now, but every day we see things coming through on the internet that are clearly people who are not licensed in California to practice law, seeking to practice law in California, or using kind of tools that might, you know, a wills and trust kind of form that you could fill out and suggesting that it might work in California. Things that go way beyond LegalZoom and Rocket Lawyer. Does the state bar, what are your thoughts on that? And do you have any thoughts about in the future as this kind of comes rushing at us? Besides these all these other concerns, it seems like non-practice of law, unlicensed practice of law seems to be everywhere on the internet.
I agree with you. I mean, I don't know if Chris or Brandon, you want to jump in. I think this is ripe for regulation, and I think that it would be great if the state bar was in a position to serve in a regulatory capacity in this space, other than by regulating the individual lawyer. But I don't know, Brandon or Chris, if you have any comments.
Yeah, just briefly, I think that the board wants to learn more about these emerging technologies and continue to study them. I know there's many facets of government that are still playing catch up in this area. And so I think that the Board of Trustees is absolutely invested in looking at these emerging technologies and figuring out how that fits in with our regulatory role.
Yeah, one of the things that we just touched on so briefly in the paraprofessional working group was the impact and the way in which the state bar coordinates with district attorneys and coordinates with our county law enforcement in terms of finding people who are doing bad things with unlicensed practice of law. One of the things I learned was that there's just not enough resources on the state side, on the on the county side and the district attorney and side. And so have either of you thought, Leah or Brandon, about how and where the state bar, where that could go in terms of trying to ferret out and find people who are not practicing law at all and truly harming our communities?
Yeah, we've on the Regulation and Discipline Committee, we've really discussed that. And unfortunately, we're not empowered to file criminal cases against individuals who are engaged in the unauthorized practice of law. We can investigate them, but we don't have the type of tools that law enforcement has, whether it's subpoenas or other investigative techniques. So so we are a little restricted in how much we can do through the leadership of Steve. We've reached out to a majority of the California district attorneys and sought to increase our levels of communication with them and working with them to make sure that they're getting information in a timely manner. Some of this really does come down to resources, allocating those resources to this specific type of prosecution. Certainly in my office and other offices, there's grant funding for various types of prosecution, whether it's workers' compensation fraud, going after unlicensed contractors. A lot of those are statute driven. And so the legislature, I think if they wanted to, could create some of those grant type programs. I think that we would certainly push for that to occur.
Mm-hmm. No, and again, just talking to regular, lawyers on the street, it gets frustrating when you see, read accounts of someone, constantly turning clients who's not a lawyer or, in our, foreign language speaking communities being taken advantage of. And then, it just feels like there should be more prosecution on that side, because I don't know, the percentage of where is the real harm coming from? Is it coming from individual lawyers or law firms, or is it really coming from people who are doing committing unlicensed practice of law? It seems that frustration in our licensees, our LACBA members, about how do we make sure those people come first in terms of getting taken out of our communities.
Steve or Chris, do you guys want to talk about things that we've done in the past and continue to do in that space?
Well, we do investigate unauthorized practice of law claims. I mean, if we are aware of it, we can open a complaint on our own, but we rely on the public as well, right? So it's a complaint driven, similar to our misconduct complaints. We have a team that investigates those cases. We do work with law enforcement. Brandon's right. I mean, we don't have the ability to file ourselves. So we're somewhat limited in that capacity. We can issue cease and desist letters. I mean, those are posted on the State Bar's website. I think you'll see those that go out, or at least some of them, portions of them anyway. But in terms of, we do work with law enforcement best we can, so they're aware of what's going on, open a case, and perhaps, I mean, I know that in the past they have pursued actions against certain entities and people. So I'm not sure if those are on the website or not, but sometimes we send out press releases, I think, that include those names and individuals where law enforcement has pursued an action against them. So we do actively investigate.
Just to provide a little context, we in 2023 we opened 845 UPL cases, and we did 300 referrals to law enforcement agencies. Mm-hmm. So I think we are certainly trying to do our part. The law enforcement reaction has been a challenge, or the law enforcement response.
And to Brandon's point, it's largely because they don't have a lot of resources either, and we don't have the tools that would be needed necessarily to do what most police agencies do, to hand them, the district attorney's office, a report that's fully investigated, et cetera. We don't have all of those law enforcement tools. We did in 2018, 2019, I believe, approach the legislature about doing just as what Brandon suggested here, or talked about here, which is providing some funding to district attorneys' offices so that they could hire people specifically slotted to prosecute those cases. And that, didn't make it through the legislature, but that certainly would be something that would then, you're not having to have prosecutors competing for resources, prosecution offices competing homicides and sexual assaults and domestic violence with unauthorized practice of law cases. And there are a number of other areas where that very thing has occurred: real estate fraud, insurance fraud, things like that. There are grants to fund those types of prosecutions.
Yeah. We don't have a ton of time left. And there are just so many things I would like to know from all of you. Really quickly, Leah, do you have any thoughts on where we're going in terms of the reciprocal licensing? Because I know that has been brought up back and forth. That's a big question. Sorry, I don't know if you can answer that quickly or.
No, I don't. We've also included the Blue Ribbon Commission that I mentioned earlier. We have a great comment in the chat about not assuming that everybody knows what we're talking about. So the State Bar and Supreme Court's joint Blue Ribbon Commission on the Future of the Bar Exam, which put forward its recommendations last year, did include a recommendation around reciprocity that would result in a more robust reciprocity experience in California, different than what we have in place today. I am not sure if that's something that the Supreme Court is going to be considering or acting upon as part of the broader Blue Ribbon Commission issues. So I don't have an answer for you today. And again, we're waiting to see what the Supreme Court decides to do with this body of admissions recommendations that it has under consideration.
Yeah, no, thank you. Thank you. We're pretty much out of time. I think we've covered hopefully a lot of the things in the Q&A, answered all the things that were really deep that I had on my cheat sheet. And I want to thank all of you for taking, this big chunk of time out of your week. And I always do this when I'm on anytime I'm speaking to people about these issues. The State Bar website has so much information. Sometimes it's hard to find. Sometimes you have to do some searches. Sometimes you have to Google, but there is so much there that is there. You can go in and you can click on all the different committees. Every committee meeting is public. All the agenda items, again, they're tricky to find and you have to click and click here and there, but you can sign up and be alerted to every single meeting that is basically held for the special committees. You can sign up for special committees. I cannot encourage people enough to really pay attention to what's on the State Bar website. But I'm hoping that, we can have you, Leah, back, and Brandon and your experts, because I think there's nothing like being able to really just hear someone, like Steve and Chris, that you have explained some really important concepts and things that hopefully people will take away from this, that there are some things that they didn't understand that they now do that will give them a little bit of relief and sleep at night. I mean, I'm joking, but seriously, these are things that keep small solo firms and small solo practitioners and small firms awake. How are you going to deal with this if a problem comes knocking at your door? So I really do appreciate, the effort you took today to help us understand.
Thank you for having us. We really appreciate it.
Stan, you gonna walk us out? I'm not sure, Leah, you weren't sure if that PowerPoint was in a way formed a.
It's not yet, but I will be sending something that can be shared out shortly, but it's not ready yet.
Yes.
And certainly, Carolyn, to your point, feel free, everybody who's on this call, to tune in to our Board of Trustee meetings. Hopefully we won't put you to sleep, but we really do talk about a lot of these issues. I think the heart of this group of trustees is, I think it really beats towards public protection, but also recognizing that practitioners are humans, and that we have to care for the human as well. So we have resources up on the State Bar website about mental health issues, especially those in the first couple of years of practice. And so we'll continue to work in that space to to help people's mental health, because I know certainly coming out of the pandemic, that's a huge issue. So thank you for the opportunity to speak to your members.
All right. Well, great. Thank you, everybody, and we'll call it a night. Take care.
Right.
Good night.
Good night.